This is case number 24-483, SC. We're here for a continuation of a creditor examination from the 8th. Mr. Holsteiner joins us, but Mr. Nason does not. I assume you've not had any communication with him to adjourning today's hearing?
No.
All right. We will go ahead and issue a bench warrant for his fail to appear.
Your Honor,
Yes,
may I approach with some evidence
such as,
that he is, my wife found out on multiple websites that he is looking for work
okay,
with his name and his crew. Ergo, if he's paying a crew, he's got money coming in.
that's more appropriate for the creditor's examination when we get to it.
Okay,
Without him here, I can't really do much about that. So we're going to issue the bench warrant with a remand. And we'll get that issued. If he has law enforcement interaction, he'll get arrested, and then we'll notify you when he's picked up.
so the bond is still what he owes me from last time?
Yes. Well, actually, now it's a remand. So he can't post a bond until we actually have him in here to find out what's going on.
It's actually arrested.
Yes. Yep.
Thank you for your time.
All right. Thank you.
We got a new court date?
No, because there won't be one until he gets picked up on the warrant.
Okay,
Okay.
thank you.
All right. This is case number 251248GC. You may be seated. We are here for a creditor's examination, if I recall correctly. A default judgment was entered on this case back on September 30th in the amount of $23,572.68. The purpose of the creditor examination is to determine whether or not the defendant in this case has the ability to pay on a judgment and possibly get set up on some payment plans. So, Mr. Collins, will you please raise your right hand?
Yes, sir.
Do you solemnly swear or affirm that the facts you give today are true to the best of your information, knowledge, and belief?
Yes, Your Honor.
Mr. Were you served? I know you were served alternatively, but were in your packet, was there this yellow sheet?
The packet was soaking wet. I notified the courts yesterday. So asked for if I could get my attorney or what, because I did not, the packet was almost unlegible. My address in the packet was incorrect. The mail's been going to a Cadillac address. I live in a McBain address.
What is your address?
9393 West Watergate Road, McBain, Michigan, 49657.
All right. So as far as the personal information, assets, all that stuff, you don't have that ready to go today?
No, I do not, but I know most of it. If I had to fill it out, I could oblige.
All right.
And I do have a question if I could ask. When I was served the first time, it said prepare a letter for 21 days. I did not go after counsel at that time. A letter was sent out to the only address that was on that. And that was like literally the last I heard of it. Steve never contacted me for anything, and the phone number on the paperwork that I could read a little bit basically was an old phone number, and we've been in contact on my new cell phone like many a times, because that's like about a 3-4 year old phone number. I was trying to basically settle before it went here.
All right. Well, all I can do is default judgment entered because there hadn't been an answer to the complaint. And so that's why I default entered, so the judgment's there.
Okay.
What I am going to do, because I have a pretty hefty docket this afternoon, I am going to reschedule today's creditor's examination. Colleen, what did we say? The 23rd was our next date. So we're going to reset that for the 23rd.
Your Honor,
Yes.
Sorry to interrupt again. If Steve would be obliged to come up with a dollar amount per month, so we don't have to do that. I can't settle it in full.
So what happens is you guys can discuss that if you want.
Okay.
We'll set it for the creditor examination. If you guys are able to reach an agreement and he's satisfied with that, he can then contact the court and cancel the creditor's examination. If not, we'll see everybody back here on the 23rd. Mr. LeGros, does the 23rd work for you?
Sure.
All right. Colleen, do you have a yellow sheet? All right. Mr. Collins, you can go out to the front window where you checked in, get your next court date. You'll have that sheet to fill out. Make sure that's filled out next time you come in. And Mr. LeGros, you can get the next court date at the front window as well. All right.
Your Honor, can I put my new phone number in there so if Steve wants to contact me so we can discuss it?
You too, you can give him
Okay.
your phone number right now, and then at the front window, if you'll give him the number as well.
Thank you. Everyone.
Ms. Campbell, are you there?
Sorry, is that better?
Yes, are you able to turn on your video?
It connected to my car. Let me try to turn my Bluetooth off. Sorry.
All right. So I know you can hear me. Are you able to see me?
I can see the courtroom, yes.
So if you swipe your screen one way or the other, it should change your view and you should be able to see me as well.
Oh, sorry.
You're fine.
Thanks.
That
I can
work?
see you.
All right, this is the case of Northern Marketing Resources LLC, versus Elizabeth Campbell, case number 251630LT. We are here after having convened on the 4th of December and started taking some testimony. The court had some concern as to whether or not the case was properly filed at that time based on the testimony, and we adjourned for some research to be done. Mr. Mitchell has filed brief in support of finding the possession issue moot and retaining jurisdiction over the money damages. I have reviewed that. Mr. Mitchell, do you have any argument other than what's in your brief, or do you want to supplement that at all?
Your Honor, I do have some additional argument I would like to share with the court.
All right, go ahead.
May I argue from here? Do you want?
Yeah, no, that's fine.
Thank you, Your Honor. Understands and agrees that possession of the premises is no longer a live issue because the defendant vacated the property in late July or early August of 2025. To that extent, plaintiff does not oppose dismissal of the possessory claim. However, Michigan law draws a clear distinction between possession and accrued money damages. Under MCL 600.5739 Part 1 in a summary proceedings action, the court may also award a money judgment for rent or damages. The statute authorizes monetary relief as an additional remedy and does not condition that relief on the continued viability of possession. That principle is reinforced by MCL 600.5750, which provides that summary proceedings are in addition to and not exclusive of other remedies, and that a judgment for possession does not merge or bar any other claim for relief. The Michigan court rules are consistent with this statutory framework. MCR 4.201 Part B permits a landlord complaint to seek possession, money damages, or both. And MCR 4.201 authorizes the court to enter judgment for possession, money damages, or both. Importantly, Michigan courts recognize that claims for money damages generally avoid mootness concerns. As the Michigan Supreme Court has explained previously, seeking redress for past injury are not rendered moot by subsequent events. Here, the damages sought prior to defendants vacating the premises. Plaintiff is not seeking future rent or post-surrender damages. Accordingly, plaintiff respectfully submits that the procedural proper course is for the court to dismiss possession as moot while retaining jurisdiction over the accrued money damages without requiring refiling as a general civil action. That approach would be consistent with statutes, court rules, and general Michigan law. Thank you, Your Honor.
Thank you. Campbell, I realize this is probably outside of your wheelhouse, but you have the right to address the argument that Mr. Just made as to whether or not the case should proceed, or if it was improperly filed. Do you have any argument in that regard?
I was under the impression that it was improperly filed. I sent in some stuff yesterday that the clerk said she would print just to prove when I moved out.
So I have received that, and I think there were text messages, if I recall correctly. Mr. Mitchell, did you receive those as well?
It was not sent to me, Your Honor, but my client received it and provided it to me.
All right. Ms. Campbell, anything else?
No.
All right. Mr. Mitchell, anything rebuttal?
I think that the texts indicate a date in the range of what my client discovered with additional research after the hearing last time, which is why we said late July, early August.
Okay. I've had some time to study Mr. Mitchell's brief. I've also had some time to do my own research on it. And I'll be honest, I've discussed the issue with a couple of other judges. And I agree that ancillary damages and relief and be brought into the the summary proceedings hearings. Don't believe it applies in this case. And let me explain why. So in MCL 600.5701, that's where we start when we're looking at summary proceedings, which is what a landlord-tenant case is. And it defines summary proceedings as a civil action to recover possession of the premises and to obtain certain ancillary relief as provided by chapter in the statute and the court rules. And then I turn to MCL 657.39. 1, and it states, among other things, that a party to a summary proceeding may join claims and counterclaims for money judgment for damages for wrongful entry, waste, or malicious destruction of the premises. I agree that pursuant to 657.50, that simply obtaining a possession judgment does not bar a claim for other damages and civil actions arising out of the transaction. So I think it's important to review the history of this case. And that's on October 22nd, a summons was filed commencing this case. And the summons specifically stated that it was for a money judgment and an eviction. That same date, a complaint to recover possession of the property was filed, alleging that the defendant remained in possession of the property, and also as a supplemental complaint was seeking money damages. At the trial on December 4th, testimony was taken from Mr. Seeley, one of plaintiff's witnesses, and he testified the defendant moved out of the premises sometime in September. Defendant stated it was in July. That's when we stopped the hearing because I had questions as to whether or not the case was properly filed, as possession was relinquished before the filing of the complaint. On or about January 6th, Mr. Mitchell filed the brief that we've discussed, which was acknowledging that the defendant vacated the premises either in late July or August of 25. In any event, it was before the filing of the case in October. Additionally, the plaintiff asked the court in that brief to allow a summary dispo finding for the possession issue as moot, and then to move forward with the money damages claim. So I go to back first that this action was brought as a summary proceeding, claiming that the defendant was in possession of the premises after having been served with a notice to quit, which we've discovered was not the case. Tenancy had been vacated before and possession had been given before the October 22nd date. The court's research indicates that a purpose as a summary proceeding is to allow the landlord to have an expedited process to gain possession of the property once a tenancy has been terminated and the tenant refuses to vacate without the landlord being bogged down in the general civil docket and the rules that go along with that civil action. Because the definition of a summary proceeding suggests that the purpose is to recover possession, it also includes, however, the ability to handle certain ancillary relief, such as money damages. This is also supported by the scale complaint form that was filed in this case, and the main portion of that form deals with the tenancy, deals with the property, why tenancy was terminated, whether there was a lease or not. In fact, that document contains 10 paragraphs, and 9 of the 10 have to deal with tenancy. Only paragraph number 10, which is listed as a supplemental complaint, has to deal with money damages. And even then, there's hardly enough room to fill that out. And as I see in most cases, an attachment has to be. So the way I see it is to allow the filing of a summary proceeding under a false claim that the defendant was in possession of the property when they weren't, and then to just simply dispose of the possession issue and move forward on the damages issue. I don't think That's in the interest of justice. I believe it's against the public policy, and I believe it's against statute. Where I believe it could have happened was if subsequent to filing of the complaint, tenancy was vacated. Then I believe we could probably move forward with the damages. However, that was not the case here. As such, I find the case was improperly filed. I'm going to dismiss it without prejudice, which means it can be brought back, but it needs to be filed in the general civil division and not in the landlord-tenant division. Mr. Mitchell, anything else for the record?
No, nothing else for the record, Your Honor.
All right. Ms. Campbell, so what that means is I have found that the case was improperly filed, and as such, it cannot move forward. But however, I have dismissed it without prejudice, which means that it can be brought back as a general civil matter, and then we'll have to proceed down the track as general civil claims do and not as a landlord-tenant claim. Does that make sense?
Yes.
All right. All right. The court will draft the order then. And we will make sure the parties get that. And as I said, I'll draft that order and both parties will receive it.
Thank you, Your Honor.
Thank you, Mr. Mitchell.